Dear students, welcome back to your education channel Learn and Educate, where we were studying a few basics about the company law. Continuing that, Section 2, Clause 56, Memorandum. Memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or this act, which states that a memorandum of association which has been originally framed or altered from time to time with respect to the provisions of any previous company law, example Companies Act 1956 or under Companies Act 2013. The various clauses of Memorandum of Association are as per Section 4 of Companies Act 2013: Name Clause, Situation Clause, Object Clause, Liability Clause, and Capital Clause, Subscription Clause. These are the clauses around which the framework of a memorandum is based. Memorandum is a document which defines the fundamental conditions. Memorandum of Association is a charter of the company and defines the fundamental conditions and the objects for which the company is granted incorporation, the basis on which the formation of company and the fundamental conditions and objects. Memorandum generally defines the relationship between the company and the outsiders. Any act done beyond the scope of the memorandum is void and ultra vires, and it can never be ratified by the unanimous vote of all the shareholders. Memorandum of association cannot be any clause contrary, cannot contain any clause which is contrary to the provisions of the Companies Act 2013. In case of any conflict between the memorandum and the Companies Act provisions of the Companies Act, then the Companies Act 2013 shall prevail. Thus, memorandum of association is a memorandum which has been originally framed or altered from time to time under the provisions of the any previous company law or under the provisions of Companies Act 2013.